Good morning or afternoon. I'm located in Alaska, so it's still morning here. But for you East Coasters, good afternoon. Um, Hello and welcome to today's National 8A Association webinar. The National 8A Association is a nonprofit with a mission to provide education and guidance for all aspiring, current, and graduate 8As. We are also proud to work with all types of small businesses, agencies, large primes, and industry professionals. Before we begin, I'd like to note that this webinar is being recorded and all presentation materials will be posted on our website. If you would like to ask a question, please use the Q&A feature in Zoom. Now I'd like to introduce you all to today's speakers, Robert Tompkins and Hillary Freund with Holland and Knight, who will be speaking on the government shutdown. So I will pass it over to Hillary and Bob. Thank you so much for being here today.
Thank you very much, and good morning and good afternoon, everyone. We are here on day 9 of the shutdown, and wanted to bring you up to speed on the latest developments, but also to share with you some perspectives on what contractors need to know as we enter into what will tomorrow be the 10th day of this government shutdown. So brief bio slides for those of you who are not familiar with us. I expect there are quite a few familiar faces on the line today, but so brief overview of what we're going to talk about, quick sort of update on the status of the shutdown, what a shutdown really is. We're going to really focus on specific impacts on small business contractors, and we'll discuss relevant FAR and government contracts legal authorities that contractors need to be aware of. And within all this, we'll talk about steps that contractors should be taking to preserve their rights during the shutdown, but also to maximize recovery and adjustment of contract price, schedule, et cetera, once the shutdown ends. So quick update on the status. We'll talk about what's going on now. We'll spend a little time talking about the contours of a shutdown and what triggers a shutdown. Then we'll talk about some big picture impacts of the shutdown in this section and provide some historical context. In the second section, we'll get into the impacts in more detail. So the current status of the shutdown, it's important to understand what this is really all about. Much of the federal government operates on the basis of annual appropriations that cover a particular fiscal year from October 1 to September 30th. So we just concluded fiscal year 25. Congress did not pass a FY26 funding bill by September 30, and therefore funding has lapsed for government agencies and functions that are reliant on annual appropriations. So such funding lapses are often addressed, at least on a short-term basis, through a continuing resolution or CR, and that CR continues the funding typically at previous FY funding levels, and it may include variations on that funding, different amounts for different programs, or et cetera. Congress has not been able to agree on a CR, and therefore there is a funding lapse, and we'll talk about how that lapse carries over and causes, in effect, the shutdown, and how that all plays out. This is not uncommon in the sense that oftentimes Congress fails to pass the new budget for the new fiscal year before the old fiscal year ends. In fact, it's happened 22 times since the mid-1970s, which is when all these concepts kind of emerged from the Budget Act. But usually they're resolved within a few days or within a few hours, and so the impacts are typically pretty minimal. There have only been 3 lapses in funding that have lasted more than 10 days. The most recent, one of the most recent was in 2018 and 2019, and that one lasted 35 days. But that only affected some agencies because Congress had passed budget appropriations bills for some federal agencies. So we're now on day 9. There does not appear to be any prospect for movement in the short term in the Congress, and so we are likely to be now in what will be the 4th funding lapse that will exceed 10 days. And as we'll talk about throughout the course of the presentation, the longer these things last, the more severe the impacts become, and for a variety of different reasons. And so this one could last quite a while. Don't hold any of this to full account, but there's currently a rumor, I guess would be the best thing to call it, that the Democrats don't intend to take any more action until what they call the No King's Day parade, which is, I believe, slated for October 18th. So that would be another 9 days. A lot of the stuff that you hear coming out of both parties, though, is posturing. And so there are likely conversations being had that are outside the public purview, and these things could go on for quite a while, or they could quickly end. And so we just don't know. But based on the rhetoric we're hearing, this one looks like it's going to last a while. So just a quick overview of why the lapse in funding results in a shutdown. The Constitution starts there. It says that agencies can't operate without appropriated funds. And so no money shall be drawn from the Treasury, but in consequence of appropriations made by law, i.e. by Congress. So again, agencies cannot operate without appropriated funds. And there's a specific law called the Anti-Deficiency Act that provides that the government cannot make or authorize an expenditure or obligation exceeding an amount available in an appropriation or fund the expenditure or obligation. That's part one. And then part two, or B, is on the slide here. It cannot involve either government in a contract or obligation or the payment of money before an appropriation is made unless authorized by law. So we'll talk a little bit throughout the presentation about the way the funding works. As noted at the outset, a lot of agencies are funded on the basis of these annual appropriations that are only good for 1 year. There are other sources of funding. There are multi-year appropriations. There are what are called no-year appropriations. There are also sources of funding that the government has that are not appropriated by Congress. And so that creates some of the potential that certain activities might continue because the funding source is not evaporated. So the Anti-Deficiency Act has some pretty specific direction, and tells officers and employees of the government that they may not accept voluntary services either. This includes services from both erstwhile employees of the federal government as well as contractors. And it further provides that, I think we have a bit of a duplicate slide here, but the second bullet point is really the key one. There are severe penalties for violating the ADA, including criminal penalties. Now, who suffers those penalties? It is the individual employees of the federal government who make unauthorized obligations, who can potentially be subject to civil fines, but also criminal penalties. And so this is something that's quite startling and impactful for federal employees. And so very, very serious stuff. And also, generally leads those employees to be very cautious about what they're doing, including direction that they may or may not provide to government contractors. So mentioned before that a lot of this sort of generated through the 1974 Budget Act. In the late 70s, there were a few funding gaps, lapses in funding, but the government continued to operate as normal. And it was at the end of the Carter administration that the then Attorney General Civiletti issued a memorandum, an interpretation of the Anti-Deficiency Act in the budget law that basically said that the government could not operate without appropriated funds to cover employee pay or contractual obligations. So it's from that legal interpretation that the concept of the shutdown as a consequence of the lapse in funding really took hold. And then there was an amendment to the ADA, the Anti-Deficiency Act, that subsequently amended it to create an exception to its requirements. Basically said that the prohibition against spending does not include emergency situations, such as those involving the safety of human life or the protection of property. And besides law enforcement and other individuals that are necessary to protect property and life and limb, individuals necessary for the private economy also may continue to work. And this includes things like air traffic controllers, meat inspectors, things that would have an impact on people's safety and the overall economy. You can imagine that there's some considerable room for interpretation about some of those things. So now we're more than 1 weekend, 9 days to be precise. And just remember that per the ADA, absent an exception or an exemption, the exception would be what we were talking about on the previous slide, that there's some important considerations such as a life and safety consideration, or an exemption because the funding is coming from something other than an annual appropriation, that generally federal employees cannot work, not on a voluntary basis. They cannot be paid, at least during the course of the lapse or the shutdown. And the government cannot incur additional obligations, including to contractors. We're going to talk about what that means in more detail on this slide. So many federal employees are likely not available to work. That will impact things like contract administration, processing and payment of contractor invoices, SBA support, things like the 8A program, the Mentor Protege program. We'll talk about each of those things as we go along. The government can also is not allowed to incur what are considered additional obligations, including to contractors. And so potentially, again, depending on the availability of funds, this may result in stop work or suspension of work notices coming out. No task order awards, no option exercises, delay in payments. And we've got a little note there to add potential exceptions to those here, which we'll talk about in a little bit. But more on these items below.
So Bob sort of already touched on this, but there is a general question about whether or not, during the shutdown, if you've got an option coming up, can the government exercise it? And generally, based on a lot of the shutdown plans that we looked at with different agencies, based on OMB guidance, the general rule is no. You cannot exercise an option when the government is shut down. There are some sort of, I guess what we would call exceptions to that general rule. So for instance, if this option that needs to be exercised is funded by non-appropriated funds, so no-year funds, 2-year funds, multi-year funds, then the government would be allowed to exercise that option. And also if it's an unfunded option, which I believe a lot of options typically are unfunded, it just extending the period of performance, then yes, but that's also assuming that somebody is there within the contracting office to issue that option. And then typically a lot of the government shutdown plans that we reviewed said that, goods or services that are needed to continue or support accepted activities, you can exercise options on those or even issue new awards. So for instance, I think a prime example would be IT services. If for some reason, right, you're paying a contractor, an entity to keep the lights on or keep the IT and the Wi-Fi on, then obviously that would be needed to continue to perform the necessary accepted activities. If you have any specific questions about your contracts, feel free to reach out, but that's the general rule here.
Yeah, and on the option exercise issue, this is, the longer this drags on, the more contracts this will impact. And so arguably, if the government fails to exercise an option in accordance with the terms of the contract by giving the proper notice and within the period of performance, that constitutes a breach of the contract and would give the contractor the ability to say, nope, we're not going to respect the exercise of the option because you didn't do it in time. Now, if you're underwater on a contract, that might be a blessing. So keep that in mind if you're in that scenario where all those stars align. But more often than not, you're going to want to keep the contract. And so that presents the contractor with a bit of a choice, which is even though the option, the time period or the process for exercising the option may have not been followed by the government, you could waive that breach in essence and agree to accept the option exercise. It may give you some negotiating leverage if you're wanting to make changes to the contract. So that becomes a matter of your business discretion. There is some risk to that process, though, because it could be viewed as an impermissible contract award in violation of the Competition and Contracting Act, because particularly if there are changes made to the contract, a third party could protest that on the grounds that this was basically a new contracting action that should have been competed. That would be an interesting scenario. I don't know that particular case, certainly not aware of a reported case on that, but again, shutdowns of this duration have been pretty infrequent. And so the longer this goes on, we're going to get into some new territory. But very interesting question on options. Bottom line, it's something to keep an eye on.
Mm-hmm. So Bob was sort of talking about exempt, accepted, and the idea of furloughing federal employees. This is important to understand in the context of what employees are still at each agency and why they're there. So the concept of exempt is essentially employees whose job functions are funded by sources other than, again, annual appropriations. So for instance, when I was at FEMA back in 2018 when the government shut down, my salary was paid out of the Disaster Relief Fund, which is considered no-year funds. So even if the fiscal year lapses, it doesn't matter. Those funds continue to be obligated, et cetera, et cetera. So during that shutdown, I was able to work because I was actually considered exempt. Not that I was important enough to be there, but because my salary and the work that I was performing was paid out of a no-year pot of fund. Then there's employees that are considered accepted, which is sort of related to the work that Bob was talking about. Essentially, that employee's salary might be funded through annual appropriations, but the work that they're performing, the tasks that they're performing, they're allowed to continue performing because by law, they are necessary. And some of that work includes the emergency work that Bob referenced earlier, involving the safety of human life or the protection of property, and or activities that an agency should continue because their continuation is necessarily implied from the authorized continuation of other activities. A prime example of this, right, is cutting checks for a benefit program where the funding remains, but if nobody's there to cut the check, then that funding is not going to go out. So they've got to keep somebody there that's considered accepted to cut those checks as required by law. So that's important. Essentially, exempt employees, there's no discretion for the government to decide who is exempt. It's a funding stream thing. Accepted employees, the agencies are given guidance by OMB and DOJ, but the agencies each have a little bit more discretion in determining how many and which positions they need to accept and have continue working during that shutdown. So one of the more important plans that we have been reviewing as it relates to the shutdown is SBA's plan, which we're going to refer to as the shutdown plan. Again, we captioned what SBA put in its shutdown plan as to accepted employees and the type of work that SBA believes these accepted employees should still be performing, including law enforcement activities, preservation of financial systems, and then again, other related activities justified by the General Counsel of SBA. So in SBA shutdown plan, they gave a list of activities that would continue during a lapse in funding, which would be, sort of accepted activities, including procurement set-asides. So there are a limited number of procurement staff that are available to provide small business set-aside program support to federal agencies that remain open. So for instance, GSA, which we'll talk about in a second, a large majority of GSA remains open because of the funding stream in which it has. And so SBA has people, that are available to the extent GSA needs assistance with set-aside acquisitions that are still going because they're funded not out of annual appropriations. Another activity that SBA mentioned that would continue is related to their small business innovation research grants and awards. Again, funded participating agencies can continue to make these types of awards. Now, the other important part here are the activities that SBA said will not be continuing during this lapse in funding, including that they will not be processing applications or providing program support for, unfortunately, the 8A business program, the mentor protege program, women-owned small business, SDVOSB. So if you had an application pending, it's probably not getting touched or looked at, with a few exceptions, which we'll touch on in a second.
It would be interesting to share with the audience how these plans come about and how often they're created. And they're not done because they're saying, oh, next week we're going to have a shutdown. But maybe you could explain a little bit about the way the process and the timing of the plans.
Yeah, so OMB requires agencies to have plans, and I believe they're required to be updated every couple of years. Again, I can't recall the exact cadence in which they have to look at these plans, update them, revise them as necessary. Obviously, if there's a forthcoming or looming one, then that's when they will get immediately updated. And then OMB requires each agency to include its shutdown plan on their website so that everybody is informed and understands sort of the limitations and restrictions that each agency is going to have to apply with respect to the work that's being performed or not performed. So that's interesting to note. And this matters because we actually took a look at the prior plan that SBA had back in 2023. And the numbers are interesting. I think the biggest thing that we noticed was that there are significantly fewer employees in 2025 total at SBA as compared to 2023. Again, in the 2023 plan, they had a total on board of around 8,000. Right now, this year, they had around 6,200. And despite having less total people, SBA has decided to furlough more people in this shutdown than they had planned for in the prior shutdown. So that's an interesting thing to note there. And then there was a significant drop in the number of exempt employees, and we'll talk about this a little bit more as it relates to certain offices. Again, exempt means that those employees their salaries were paid out of appropriations that were not annual appropriations. So for whatever reason, whatever other appropriations, those 2,000 employees from 2023 were getting paid out of lapsed or, ceased funding, or they ran out, which is why there's, less exempt employees this year. Another category that we didn't really talk about because it's somewhat obvious that are not furloughed or that continue to work during a shutdown are presidential employees. So at SBA, that includes the administrator, the deputy administrator, the inspector general, which the position's vacant right now, but that position, because it's presidentially appointed, if there was somebody filling that position, they would still be required to work during this shutdown. And then the chief counsel of the Office of Advocacy. So in addition to those presidential appointees, within the SBA's Office of Administrator, there's 2 additional positions that are considered exempt, and then 10 positions that SBA designated as accepted, and then the rest, the 28 employees within that office were considered furloughed.
So within this data, as Hillary was pointing out, there's definitely information about the impact of the shutdown, but the plan itself is also revealing about what the SBA staffing is like before the was like before the shutdown, and what it will apparently look like afterwards. It may be worse after the shutdown ends, but this next slide has some important information about that.
Yeah, so the SBA's Office of Government Contracting and Business Development, which I'm sure you're all familiar with because it's the office that sits above, the 8A program, all of the set-aside programs. If you look at the numbers compared to the 2023 plan versus the 2025 plan, there's fewer employees this year that they started with before the government shut down. So approximately only 40% of the workforce from 2023. Again, as I noted, the biggest drop overall at SBA and within this office is the number of exempt employees. Back in 2023, the Office of HubZone had about 15 positions that were funded from 2-year funding, and 23 positions from the Veteran Small Business Certification Program that were funded from 2023, or that were funded from 2-year funding. This year, there's only 1 position within the Office of HubZone, and then 2 positions within that Veteran Small Business Certification Program that are available and considered exempt, again, because of their funding stream. Now, the number of accepted employees is around the same. It dropped by 1 as compared to the plan in 2023. And then, again, what's interesting is that despite having a significantly fewer amount of staff available, they actually have furloughed more staff this year than they had anticipated furloughing in 2023. And so, if things were moving slow before the shutdown, they're certainly not moving anywhere right now.
Yeah. And, again, beyond the shutdown, there have been a number of observations about the slowdown in things like the processing and granting of 8A applications, which had really come to a nearly complete halt before the shutdown. And then, as Hillary noted, we're going into the shutdown, we're about 40% less of workforce at SBA. By some measures, that's calculated to be even more severe. And those numbers were put together before the final tranche of government employee buyouts, which went into effect on September 30th.
Yeah.
And so certainly there were additional people who have since permanently left the agency as a result of those. So it's a very severe downturn at SBA in particular.
Okay, so GSA shutdown plan. This one's interesting, especially when you contrast it to SBA, because a lot of GSA is actually funded by what's referred to as self-revolving funds, and that they just get replenished through fees that are paid to GSA for its performance of work for other federal agencies. So according to GSA shutdown plan for this year, the total number of GSA employees onboarded, prior to September 30th was around 10,000. And of those employees, 64% are considered either exempt or accepted, the majority of them being exempt because of their funding stream again, funded from other than annual appropriations. GSA listed out sort of its accepted activities, which are pretty general and broad and more or less align with sort of SBA's accepted activities, including performing contract obligations under no-year, multi-year, or other funds available for these purposes, and then supporting and providing services to other federal agencies to help them perform their accepted activities. GSA has a lot more offices that are open, like almost completely open. The ones that are completely funded through the Working Capital Fund, which is one of those revolving fund, are the Office of Chief Financial Officer, Office of Human Resources Management, General Counsel, GSA, or GSA IT, Civil Rights. So the Working Capital Fund was created by Congress, it's created by statute, and it was essentially provided this pot of money that GSA, where they were performing sort of common administrative services. So they provide all of like the printing services for all the federal agencies, but they charge every federal agency a fee. So they put that fee into this fund and then just keep replenishing themselves and paying salaries and the work out of that fund, which is why a bunch of these offices are able to remain open despite the shutdown, especially as compared to other federal agencies.
Yeah, so given that GSA has become kind of the centralized buyer for the government, the status of what's going on at GSA is very important and will have an impact on many contractors. Hillary's going to now share a little bit more information about some of the specific contracting programs that GSA administers that will be of interest to you.
Yeah, so within GSA, there's its Federal Acquisition Services, which I'm sure you're all familiar with. They're sort of the office or the branch that manages the Multiple Award Schedule program, and they're funded through what's referred to as the Acquisition Services Fund. The Acquisition Services Fund is funded in part through the Mass Industrial Funding Fee, which I'm sure you're all, if you have a GSA Multiple Award Schedule, are used to seeing in the contracts, which is a fixed percentage of reported sales under, the schedule contracts that are required to be allotted to this acquisition services fund. So again, Federal Acquisition Services, that branch or office is remaining open because it's funded through appropriations other than annual appropriations. Approximately 2,600, 2,700 of GSA employees are funded through this separate fund again. So that's how many employees are still at GSA, still working, still churning out contracts to the extent possible. Now GSA in its shutdown plan sort of gave some guidelines in terms of what goods and or services you can or cannot purchase. And they said, again, obviously you can't purchase goods or services under lapse appropriations, except when they're required to support accepted activities, or when they're purchased again from funds that are exempt from the lapse, again, such as the ASF. This also includes awarding new contracts or exercising options unless obviously they're awarded out of exempt funding sources. So if they're awarded out of exempt funding sources, then you can award the new contract or exercise that option. But if it's awarded out of annual appropriations, then you can't do it.
So an important takeaway is that GSA is going to be able to continue to operate its functions, but because it serves as a buying agent for other agencies and spends their money for them, if those agencies don't have the funds or don't have the personnel to see the process through, you will see those orders for customer agencies impacted by the shutdown to the extent the customer agency is impacted. Mm-hmm. So, but if you do have a multiple award schedule, this would apply to other GSA vehicles like Oasis. In theory, GSA is equipped to continue administering those contracts, so exercising options, issuing modifications, making new awards. And again, those, as you know, those contracts don't necessarily obligate money right away because they're order-based. And so keep an eye on your GSA contracts and don't assume because the shutdown is in place that things will necessarily come to a screeching halt. So be on the lookout for notices from any contracting officer, but GSA contracting officers in particular.
Right, but note that like the longer that this drags out, the GSA does have, a contingency plan for sort of phasing employees out to the extent that the funds start dwindling more and more. If the government isn't open, in a month or 2 months, depending on, they're going to have to keep reassessing how much is left and how much they can use and how much they need, et cetera, et cetera.
So GSA, interesting situation. What about disputes and protests?
Yeah, so GAO is closed. If you try to go to EPDS to file anything, it's not operational. You can't even log in. You can't, their website says such as well. GAO said that it will toll decision deadlines for a period of time equal to the length of time that GAO is closed. So if GAO was closed for 6 days, then then that deadline decision is extended by 6 days. They still have to actually report it to Congress because it is a statutory deadline. The 100-day deadline is statutory. They still have to report those decisions that did not meet that 100-day deadline, but because of the shutdown, I don't think there are necessarily any consequences of that. The deadlines for filing new protests. So if you had a new protest that was, you're getting ready to file, they are extended to the first day that GAO resumes operations. So essentially, they're saying that this shutdown operates in the same manner as when a deadline falls on a weekend or a federal holiday. So just have everything in place for the day that GAO and the federal government reopens to get it into EPDS as soon as possible. Now, if you had a pending case at GAO, they said that any other filing deadlines are extended again for every day GAO was closed. And they gave an example. So if they were closed on the 1st and magically the government decided to was able to reopen with 5 days. If your report was due on the 3rd, then it would be extended by 5 days and due the 8th. So that's a little bit of math that everybody will have to do. So we'll see how long this holds on and what happens to those deadlines. And another thing that Bob and I and a lot of our colleagues and even some of our clients have been contemplating is, well, what happens with the SICA stay?
Right.
That's a statutory thing. If you don't file within 5 days of your debrief or 10 days of award, or under the DOD, what happens, right? If you file the day the government reopens, do you still get the SICA stay?
Our interpretation is probably because within the SICA statute, there's language about, holidays and weekends and such, and discussion about if the government is closed for reasons such as that. But it could raise some interesting questions. And of course, as you know, oftentimes there's a rush to push money out the door before September 30th, which triggers protest deadlines, right at the end of the fiscal year. So it's really one of the busier times for awards, but also for protests. And of course, with the disruptions at GAO, potential protesters need to be mindful of what the impacts are, including on the SICA stay. And then we talked a bit about SBA, but within SBA, of course, you have the Office of Hearings and Appeals.
Yeah, so OHA has no employees that are considered exempt, and SBA has identified no employees that are considered accepted. So for all intents and purposes, nobody's at OHA, the lights are out.
Yeah. Now, other places where you might bring protests or appeal claims would be the Court of Federal Claims and the boards of contract appeals.
Yeah, so the Court of Federal Claims is open, but because DOJ, obviously, who is the representative of the government, is impacted by the shutdown, expect postponements, expect requests for extensions or requests for stays if you haven't already seen them in your filings. It is interesting, 89% of DOJ is actually not furloughed. So it's unclear how many or what, if any, certain civil cases are remaining, or if the majority of those DOJ attorneys are related to criminal cases. And then the boards of contract appeals is interesting. The CBCA is open, but the ASBCA is closed. The CBCA did say they're open until October 31st, and then they're going to have to reassess depending on how much money they have left. They have actually canceled all conferences and hearings, but we have heard that except for statutory deadlines, each judge has sort of been given discretion as to whether to modify specific deadlines within their cases or not. Again, ASBCA is closed except for they're open to receive new appeal filings.
Yeah.
So if you've got an appeal filing with a deadline at ASBCA, file it.
Yep, exactly. Well, we're going to move on to our next section now. We've given sort of the high-level overview. And by the way, if you have any questions, please put them in the chat, and we'll take a look at those as we have time. But now we'll get into some of the specific impacts that the shutdown is going to have and is having on contractors. So remember the basic rule under the ADA that agencies cannot incur obligations in advance of or that exceed an appropriation. So where the appropriation has lapsed, as many of them have, an agency cannot incur new obligations. And as Hillary discussed, this includes new contracts, task orders, or even exercising options, except in very limited circumstances. So one of the key things you want to look at as a contractor is your actual contracts and look to the extent to which funds have been obligated to the contract. Just because the funding lapse occurred September 30th, if money had been put in, obligated to your contract before that, and was available through an appropriation, which it should have been, you may have some runway left on your performance based on the amount of funding that was previously provided. So you need to look contract by contract to see how this is likely impacting or will likely impact you. So a few different things, and we'll get into some other specific FAR clauses later. But FAR Part 32, which deals with contract financing, requires the government to either fully or incrementally fund fixed and cost type contracts. So back to the point that look at the extent to which your contract has been funded. The FAR adopts the principles and implements the ADA. So it is consistent generally with what the ADA requirements and limitations are. You want to look at things within your contracts like the limitation of costs or limitation of funds provisions or clauses. And again, assess your contract type, which is an important consideration in terms of the manner in which you'll be paid and what you will be paid for. And as we'll talk about, this also has some impacts on your ability to recover post-shutdown, which we'll be talking about later in the presentation. And then don't forget about the Prompt Payment Act. And we'll reiterate this a number of times, but here's the first shot at it. Submit your invoices as you normally would. And because once that invoice is submitted, even if there's nobody there to process it within the government, the Prompt Payment Act payment periods begin to run, and the interest that you are owed on untimely payments can be significant. And so, don't assume that because the government is closed or your contracting officer is not at work, that you should not be submitting invoices for work that you've actually performed. Quite the opposite, you should be submitting invoices in a timely way. So what happens if the ADA and FAR requirements are not followed? Again, the contracting officer may be committing violations of the ADA, as we talked about, but from a contractor perspective, you're likely going to be providing improper voluntary services, which we discussed above, and that puts you at risk. So if your contractors run out of funding, you're now in a quagmire of what do you do? Do you simply stop, or do you keep performing at risk? You may not be able to get any direction from a contracting officer who's been furloughed. So that's potential quagmire number one. And number two is set forth on the slide is, well, what if you reach out and they say, oh, don't worry about it. We'll deal with this later. That presents a real tricky situation for a contractor, and you'll just have to balance your desire to continue working with the legal implications of working on a voluntary basis, putting you at risk, meaning that you really have no basis to collect payment. But we're going to talk about some of the nuances of that scenario and how you can manage around it and how you should document your efforts to deal with those things with your contracting officer.
And just as a side note, there is a way to unmess ratification.
Yeah.
That can happen after the fact. It doesn't always happen, but if there is an issue, talk to your KO about potentially ratifying any work that you performed at risk. To the extent they're able to do that, you have to do a whole justification. You have to get certain proper approvals. It might not be an option because nobody wants to sign off on it, but it's there. It doesn't mean continue performing work. Again, there's still a risk that it won't get ratified, but you're not completely screwed.
Yeah. A lot of discretion there for the contracting officer and the agency about whether they will actually ratify and pay you. But that is the correct, one of the legal mechanisms to sort of set things right after the fact.
Right. So Bob sort of already talked about this, but if you haven't already, it's really, again, important to determine the contract type, how it's funded, and which FAR clauses are included. Again, understanding the funding source. This is really important. Annual authority, which is what contracts are typically funded under. Multi-year authority, no year authority. Again, FEMA, the disaster relief fund is an example of no year authority. Fees or other non-congressional sources. I'd say, the GSA Acquisition Services Fund and the Working Capital Fund would fall under that sort of category. And then figure out, was it fully executed and funded prior to the lapse? How much money did you have left, if any, to help you figure out your risk assessment, how long you can continue performing, and what you should do next if you don't have the money.
And one of the reasons we encourage contractors to look at their own contracts and not wait for the government to tell them what to do is, first of all, the government people may not be there to tell you what to do.
Mm-hmm.
But secondly, this gives you a bit of a predictor of how things are going to play out. And you can look at those contracts and realize that, okay, we have funding through October 21st that was put in place before the lapse occurred. And so, but then that on the 21st, that's when the runway ends for your funding. And unless the shutdown is lifted and more money is obligated to your contract, you're now going to be in that at-risk situation. So what you can be doing between now and the hypothetical October 21st is developing a communication chain with your contracting officer to say, hey, this is our interpretation of how our contract is funded. Here's what we plan to continue to perform to the extent we're able to up until the 21st, but our funding will lapse. Please provide direction. You may be sending that to an unmanned email account, but you should definitely be documenting things like that. So, one of the key reasons to assess your contracts is to give yourself the ability to kind of have a time horizon and a basis to predict when this is going to really become an issue for you.
And this is where the shutdown plans might come in handy, because if your specific KO is furloughed, then you might be able to look into those shutdown plans, see who the higher head of contracting activity, if they were exempt or accepted, and figure out if you can find their email and shoot them an email to let them know so that maybe they can take some action, or funnel it down to a KO that's still there that can take some appropriate action, if at all.
Yeah.
So again, we have a little bit more information on each of these specific clauses, but these are the clauses that you should be on the lookout for: the suspension of work, stop work order, government delay of work, your changes clause, and again, as Bob mentioned, the Prompt Payment Act. Some of these clauses are only applicable to certain types of construction or architect engineering clauses, so they might not be in there. If there is not any single one of those in there, then that's also something to consider in terms of having to necessarily recoup any costs, although I guess the changes clause would apply. But make sure you're taking full account of what clauses are in each of your contracts. And if the KO did issue a stop work order or suspension of work order, maybe make sure that actual clause was in your contract.
Always a good thing to check. So the first two provision clauses that are listed here are mechanisms that the contracting officer can use to basically tell you to put things on hold. We'll talk a bit about the particulars of those and what remedies and limitations they might have. The last three are really things that provide you a potential remedy as a contractor. So we'll get into more detail on those as we go along.
The next thing you should have done or should be doing if you hadn't, or you still have a little bit of money left on your contracts, is to look at your subcontracts and your vendor agreements. Do they have any clause in there that addresses a shutdown? I know after the 2018-2019 shutdown, a lot of contractors added in their force majeure clause a shutdown activity of the federal government, like specifically to account for that. Do your subcontracts and vendor agreements flow down the suspension of work clauses, the stop work orders, so that, if the government issued one to you, you can issue one down? What notice requirements are included in order to sort of abide by your contractual terms with your suppliers and vendors? And then what do they say in terms of payment? Hopefully, if there's any subcontractor performing under one of your federal prime contracts, your payment clause included a pay when paid clause. Or if not, make sure that you understand what the implications of that are, whether you might be having to cover subcontractor expenses out of your own pocket until the government turns the lights back on.
And we generally recommend, at least for primes, that they have a pay when pay clause.
Mm-hmm.
If you don't, this would be a good reason to start thinking about putting those into your subcontractors if you're a prime.
Next, again, Bob touched on this a little bit, is you monitor communications from the contracting agency to the extent that you're receiving them. Make sure you're saving any communications that you receive before it shut down. Remember, only an authorized or warranted contracting officer or representative can issue a stop work order or termination for convenience. So make sure if you've gotten any notifications, it's from a person from the agency with the requisite authority. Again, if you didn't have any communication, you've sort of got to proceed to the extent that you have funds. If you didn't have a communication and you don't have any funds, then communicate with your contracting officer, even if you're sending it into a contracting officer that isn't there. Make sure that there's something in writing that's setting forth sort of the implications of what's going on with each of your specific contracts. Again, if you were formally directed to stop work by the KO, then start winding down and stopping work and, you know, advising your subs of the same. And again, document everything in writing. So this is going to help you recover those costs on the back end. That's why we're emphasizing this.
Yep.
And then act on communications from the agency, which is sort of, it ties into the last slide that we talked about. Again, if you were told to stop work, then stop work. Tell your subs, follow up with the KO and your subs in writing to confirm compliance. Make sure that they actually put all the necessary stops and turned off the necessary buttons and flipped all the switches so that, you know, nobody's incurring any costs that they shouldn't be. Because a part of your obligation, if you do want to recover for having to sort of wind down and ramp back up, is you have to show that you mitigated your costs. So if you submit an REA for costs that your subs continue to incur, and there was no reason why they should have, then you might not be able to recover those costs from the government. Again, document all of this, track your costs, set up separate charge codes for, you know, costs incurred to wind down, costs incurred during the shutdown, et cetera.
Yeah, so the tracking of costs and keeping records is really super important. We'll talk a bit about some of the details as we go along here of what you should be tracking, but among other things, you should be tracking the costs of implementing any stop work or suspension of work order, and, you know, set up cost centers or cost charging codes internally to track the expenses related to winding down and then ultimately starting back up your operations on contracts. Recommend that you advise your subcontractors to do the same, because all of those wind down and wind up costs are potentially recoverable through request for equitable adjustment after the shutdown ends. And so, you know, the time that you're spending, frankly, potentially even the time you're spending today learning about the shutdown process and what you should do, you know, get those internal cost codes set up right away and make sure people are allocating time to them. This thing goes on, and the longer it goes on, it has the potential to impact your indirect rates, and that is a whole kettle of fish we won't get into detail on today, but you've got overhead, you've got G&A expenses that you're continuing to incur while the shutdown goes on. And again, the longer it goes, you're going to have a bigger chunk of those expenses that you may have to give some thought to as to how you're going to allocate those. You know, it may involve some reallocation of those indirect costs. You also have a duty to mitigate costs. So we'll talk a bit more about that, and those are discussed in some of the later slides. But, you know, if they've told you to stop work and you don't have another place to park your employees, you need to be thinking about how do we, you know, ratchet down the employee costs with the idea in mind that you also need to be prepared to start back up. So demonstrating that you've at least given consideration to how to mitigate costs and document that along with everything else. And again, we will come back to this time and again, under the Prompt Payment Act, continue to submit invoices that are on time, assuming that you performed the work, and track the government's Prompt Payment Act obligations. So what happens if you don't get a stop work order, but your performance is impeded by the shutdown? This could happen for a number of different reasons. You know, for example, if the contracting officer is furloughed and the government personnel that administered your contract are not there, but you haven't received a notice of stop work, but you know, that might impede your ability to perform, or the administration of your contract. Things like processing invoices could be delayed. Inspection and acceptance of your work may come to a halt. What happens if your work is performed at a government facility and that facility is closed because of the shutdown? You may not have gotten your contract may be funded and you may not have received any direction to stop work, but if you can't get into the building where the work takes place, your ability to execute is impeded. And so this creates risk for contractors and frankly grantees as well. But it's important to document the impacts of things like this and report them in writing to your contracting officer to create a record. And so what should you be doing? You should be assessing both the costs incurred and the impacts on things like schedule and performance of these, what I would call practical impacts, again, i.e. a government facility being closed. Communicate that promptly in writing to the contracting officer and note the nature of the impact, how it was a government caused impact, and what the actual impact was, both in terms of cost, performance, and also schedule. And so, again, you should take efforts to mitigate those impacts. If the people who are working at that government facility could perform that work remotely, you might want to look into whether that is a mitigation technique that you could employ, just as an example. Continue to submit invoices in a timely way. We're going to harp on that because it's super important. So more detail on this in the final section of our presentation below in terms of what some of the particular FAR clauses are. So even if, again, if you've got funding in place, determine whether and logistically you can continue, what other impacts you're going to incur. We talked about the workplace. Are government employees there to continue working or accept deliverables? A lot of times your employees are working alongside government employees, maybe on a project together where the government employee is sort of acting as a supervisor, not that you would enter into personal services contracts, but those close working relationships may be impeded. That could impact you. And again, talked about this before, contract administration functions, including making payments, may be impacted. So again, just the communication thread and the documentation of all this is super important, and make sure you're papering up the file on all of these things with your contracting officer or whoever, preferably both. So some other things that might implicate the contracting process. What if you have an RFP that was issued with a closing date of October 9th? Absent an amendment to the solicitation, you should go ahead and send your proposal in. We had an anecdotal experience where a client is in that very situation, and there were some pending Q&A that had not been answered. And so that creates a tricky situation. Do you take a chance and see if they'll extend the proposal submission deadline after the shutdown ends? I think that would be a risky thing to do because they might not. But yet you've got this unanswered Q&A. So I think some caveating to your proposal to say, we're submitting this in accordance with the deadline, but we know that there are outstanding questions and answers that may impact our proposal. And we request that the government, when it reopens, extend the proposal deadline, address the Q&A, and allow for resubmission or submission of revised proposals. So we talked earlier, Hillary touched on some of the impacts at the SBA, 8A applications, Mirror Protege, et cetera, ground to a halt. HubZone continues to some degree because they have at least one employee who's in the exempt category. But, and then, to the extent you have export control related issues, the State Department is significantly impacted. And so we've identified some of the things there. E-Verify may be unavailable, and so you may have difficulty onboarding new employees as a result of that. And then generally speaking, pending rule making processes are suspended. So what about employees? We did a seminar with a few of our colleagues, including Tim Taylor, who's a labor and employment lawyer, on September 30th. We've included a link to that here. Tim had a section of that presentation where he talked about employee issues. But one of the things you should be looking at is determining the status of your employees. And if you receive a stop work or suspension of work notice, let's say, for example, you have employees who are remotely located, maybe performing overseas. Does it make sense to go through the expense of flying them home? You do have the obligation to start back up at some point, and you are entitled to recover those startup costs. And so if you decide to keep them in the remote location, I would prepare a written justification for why you decided that would be better for you and the government in terms of cost and perhaps the ability to retain the employee. And so, you'll have some decisions to make about that. Looking at their employment status is certainly an important thing to consider. And we'll touch a little bit on some of the other employee-related issues later in the presentation, but our September 30th presentation has a more robust set of discussion points there. We'd be happy to put folks in touch with Tim or others in our labor employment group to talk about those.
And I think it's also important in terms of like if your contract has key personnel, right? Part of like the mitigation strategy is seeing if you can place your employees somewhere else. But if you've got a key personnel and you have to remain on standby to be able to ramp back up once the government opens, then it might not make sense to put a key personnel, assign them to another task that might overlap in the event that the government reopens. So those are considerations that you have to think about in terms of, again, a status of your employees and what to do with them in terms of mitigation, et cetera, and making sure that you're documenting all of your decisions in writing. That way, when it opens and you request those costs, you'll have something in writing that explains your decision making.
Yeah. Another big consideration is many contractors rely on lines of credit or other financing arrangements. Make sure you review your financial loan documents, particularly look at the covenants. Generally, those covenants, will provide that you must notify your lender in the event of certain events, disruptions in your revenue stream, termination or suspension of work can all trigger obligations that you would have to your lender. And so, make sure you give those a look and understand what the impacts of these things could be on your loan agreements. Depending on those covenants, it could constitute an event of default, which could result in a loss of access to that line of credit. So, also, work with your counsel to figure out if you see any significant problems in your loan or financing documents, how you're going to notify the lender. So project compliance, make sure that you're taking steps to be open with your lender and keep that dialogue going. And so, again, just, important to keep an eye on the loan documents. And then, again, work with your lenders and your counsel proactively to make sure that even if you might technically be out of compliance with your covenants and loan documents, that you kept the lender informed so they might have some comfort in what's happening and how you're going to handle it. And again, the longer this goes on, the tougher these impacts are going to be. So another important thing to keep an eye on. So when the shutdown ends, and you need to be prepared to start work quickly and then seek reimbursement for all the costs that you've incurred as a result of the shutdown. So again, document the stop work, wind down expenses and the startup expenses that you incur. Be prepared to submit requests for equitable adjustment, typically under the changes clause or perhaps under the government delay clause. And consider, among other things, the employee costs and your overhead implications. You'll also want to be communicating with your employees as best you can to let them know what you're expecting of them, both during the course of the shutdown, should they be impacted, but also in terms of starting back up. Again, remember to invoice for your prior work and consider whether additional interest payments are due under the Prompt Payment Act. And then details on the particulars of the reimbursement avenues will follow. And with that, I'll turn it over to Hillary to talk about what costs you may seek to recover.
So this is just sort of a general high-level overview in terms of thinking about what your REA and what costs you want to claim. So for instance, direct costs that you incurred to maintain your employees, maintain your facilities, your equipment that you had to go idle due to the shutdown, and that you had to keep so that you could immediately resume work, right? So it was reasonably necessary to keep this facility. It was reasonably necessary, as we talked about, to keep this employee because you needed them for when the government decided to reopen or was able to reopen. Again, we touched on this earlier. It's got to be subject to reasonable efforts to mitigate these costs and document the mitigation steps that you took or why you couldn't mitigate those costs. For instance, if you had a facility that was solely devoted to a federal government contract, and it was a 10-year lease, you wouldn't try and pay those fees to get out of that lease and essentially needed that facility to remain within your possession once the government opened back up. That's a reason, that would reasonably justify not mitigating that type of cost. Again, this includes salaries and benefits actually incurred to maintain the employment. Costs, again, we talked about sort of for ramping down and ramping back up. that were caused by the shutdown, and then any claims by your subs that experience these sort of same costs in order to wind down again or ramp up or keep any of their necessary employees on board in order to immediately be able to resume work. Again, subject to their ability to mitigate. So make sure you're communicating with them that they've got to take reasonable steps to not incur any costs that are unnecessary. We're going to talk about this for the 5th time in case you weren't listening for the prior times that we said it. Make sure you're tracking your costs separately in separate charge codes, right? Separate charge codes for winding down and a separate charge code for ramping back up. That way you can track them and document them. And then when you submit your nice little REA, it'll be in a nice little package, all tied up, ready to just be immediately paid. There is at least one helpful case that was issued a while back where they talked about reasonable costs incurred by a prime and sub to maintain readiness to resume performance after a stop work order was rescinded and was allowable as an equitable adjustment to the contract costs. So document your costs, track your costs in separate cost codes, inform your subs and inform your employees as to the sort of things that they should be charging to different cost codes, et cetera, et cetera.
And then touch briefly on indirect costs, and we are scheduled to go to 2:15, and I reiterate, if you do have questions, please put them in the chat, but we're coming into the home stretch here. Indirect costs, again, the longer this drags on, it could have some impacts on your allocation of overhead and G&A and fee, et cetera, on your direct costs. If you're going to need to reallocate unabsorbed indirect costs that were originally priced into the contract, that is another consideration as you proceed with requests for equitable adjustment. The actual cost of preparing the REA, including professional assistance from accountants and lawyers, is part of your contract administration and is generally permissible, allowable as part of your REA. And this also includes, again, your own internal time that is spent not only doing the wind down, get back to work, but also the actual preparation and the documentation development that you provide. And then the Prompt Payment Act, maybe you've heard of this. Here's a summary of what it provides, but the important things are that, first of all, properly submitted invoices are required to be paid within 30 days. Otherwise, interest begins to accrue. For small businesses, there are special requirements, and here again, check your contract to confirm that they're in yours, that require payment in as little as 15 days. A few years ago, this didn't matter as much because interest rates were so low, but now the Prompt Payment Act interest rate is 4.625%. Gets reset every 6 months, and so that's potentially real money, especially if you have invoices that don't get paid for quite a while. So remember that. You're not required to submit any type of affirmative claim to those interest payments. The government is supposed to automatically calculate and pay those. But if that does not happen, you should be in touch with your contracting officer to remind them of those obligations. So again, document the timing and acceptance of work and the submission of your invoices. You'll keep a record of that. It's unclear to me how the other side of the process will work in the various invoice submitting platforms that are used, but make records of when you put them into the system so you can demonstrate that, of the day on which you submitted the payment, the invoice, and from which the PPA timeframes began to start. So we're going to spend a few minutes just going through some of the actual clauses here as we wind down. And Hillary is going to talk about stop work and a few other clauses.
Yeah, so the stop work order, this sort of reiterates a lot of the general things that we've been talking about. It says, you have to take reasonable steps to minimize the incurrence of costs allocable to the work. If it's issued and canceled, then the contractor shall resume work. Again, contractors, you may continue to incur costs reasonably necessary to maintain ability to, again, immediately resume work. So because of that contract, that specific language in that clause, that gives you a hook to sort of ask for those readiness costs, those employees that you had to keep on hand for the ability to start back up once the government reopens. Again, to the extent that you can mitigate, though, so that's important to remember. But these are sort of the guidelines in the clauses, and the clauses that you should see whether or not are in your contracts.
And a lot of this is difficult because nobody knows how long this thing is going to last. And so it would be worth looking, first of all, making sure if you got a stop work order, that's important in and of itself. But the stop work order typically will provide some sort of a time frame for how long you were to stop work. And I think it could be up to 90 days, but look to see if they give you a specific number of days or if it's contingent upon the government reopening. There are a number of variations that could take. But particularly if it's of a short duration and they're going to just incrementally extend it, or if they're unspecified in terms of how long it will last, I think this supports your position that you need to maintain the readiness to start at the drop of a hat. I mean, this thing could end 5 minutes from now. Probably won't, but it could. And so you need to be ready to crank right back up. And so pay close attention to the terms of the stop work order if you get one, and what that means in terms of your readiness and your ability to mitigate.
Again, the stop work order actually gives you that hook to submit your REA. It says the contracting officer shall make an equitable adjustment to not only the schedule, but the price or both to the extent applicable, which I assume both will be applied in this instance. And you have to assert your right to your equitable adjustment within 30 days after the end of the period of work stoppage. So make sure that you're putting that deadline in your calendar the second the government resumes, so that you know when you have to submit that equitable adjustment. Now, I believe there's some leeway for the contractor to extend that deadline if you're for the KO to extend that deadline if you're communicating with them. But make sure that you're aware of the specific submission deadlines within each of those clauses for which you intend to request an adjustment based on, and putting it in your calendar. At this point, because you're documenting your costs and everything's already in writing, hopefully it shouldn't be too hard to compile all of that information into an REA and to submit it within that timely manner. So the suspension of work clause, it's similar. Again, it says if the performance or any part of the work is for an unreasonable period of time, suspended, delayed, or interrupted by an act of the KO in the administration of the contract, an adjustment shall be made for any increase in the cost of performance, excluding profit. So that's an interesting thing to note. You cannot apply profit if you're using this clause to try and get costs related to this shutdown. It doesn't apply to delays caused by your own negligence, or for which an equitable adjustment is provided for or excluded under any other term or condition of the contract. So that's a little bit of an interesting qualification for use of this suspension of work clause, but it does, again, provide you for an increase in your cost of performance, but just not profit. So it shall not be allowed under the suspension of work clause. You can't request costs that were incurred more than 20 days before the contractor should have notified the KO in writing of the act or failure to act, unless the claim in an amount stated is asserted in writing as soon as practicable after the termination of the suspension, delay, or interruption. So that's an interesting caveat that you should be aware of. Again, if you didn't receive any comms from your KO, again, make sure you're putting everything in writing, even if it's going to a mailbox that's not getting looked at, making sure that you're asserting that, hey, I have no funding, the government shut down, I'm incurring all these costs, et cetera, et cetera. There's this clause that, I intend to submit reimbursement for. And then again, reiterating the same the second the government opens.
Yeah.
You can't talk to them too much, even if you're getting nothing back.
Yeah. So similar clauses Hillary was talking about are clauses that will be invoked by the contracting officer, stop work or suspension of work. Government delay of work provided this clause in your contract, gives you, the contractor, the ability to seek a request for adjustment if by an act of the contracting officer, in the administration of the contract that is not expressly or impliedly authorized by the contract, you're entitled to an adjustment, again, excluding profit, for any increase in the cost of performance that is caused by the delay or interruption, and the contract is modified in writing accordingly. So similar thing tells you, like the other clauses Hillary discussed, that you do have a path to recovery, and it involves certain prerequisites that have to be met. It also provides that an adjustment to the delivery or performance dates can be sought, and similarly, it doesn't apply when you've got negligence, or if there's another means provided for in the contract. Um, Similar to the suspension of work clause, there's a 20-day period to provide notice, and same considerations that Hillary discussed apply there. The other big one is the changes clause, and so this is a clause that permits the parties to agree, typically through the request for equitable adjustment process, to changes to the contract, which can include the description of services, the time of performance, place of performance, and also including potentially cost or price impacts. And so this is another one to keep in mind. This will be a mechanism that you would use to address the impacts of the shutdown. So on changes, similarly, you've got a 30-day window to assert your right from the date of if it's an order that's presented by the contracting officer. You may want to affirmatively assert a request for equitable adjustment, even if there's not a modification proposed. And so you ultimately, you want to keep this in the request for equitable adjustment realm. That is deemed to be a matter of contract administration, and during that process, you can seek to recover your actual costs for going through the process. If you come to an impasse, then it can be converted into a claim under the Contract Disputes Act. But once you turn it into an actual claim, your ability to recover your costs for pursuing litigation, i.e. a claim against the government, fall on you. So
yeah, the government's not going to pay you to sue it.
Yeah. And then here again, just because this is an important point, we included again the Prompt Payment Act discussion, but that takes us to the end of our session. And I don't think we have anything in the chat. So barring any questions, we thank you very much for your attendance. Our contact information is in the bio slides that we provided, and if there's anything we can do to help, please let us know. Hopefully this wraps up soon, but I'm not particularly optimistic. So thank you again for your attendance, and good morning and good afternoon.
Thank you. Again, if you would like to ask any questions, please ask them in the Q&A. We won't be tracking it in the chat. I think somebody had asked or had mentioned that the chat was closed. All questions should be put in the Q&A. And additionally, as a reminder, registration for the 2026 National Small Business Conference is open. If you are interested in attending, please visit our website to register. The event will be taking place in Nashville at the Gaylord Opryland on January 26th through the 28th. And I'm not seeing any additional questions here. So big thank you to Bob and Hillary for today's wonderful presentation. And as mentioned before, this will be available on our website. Thank you so much.